House to Home gives practical tips and recommendations to keep your house up to date. Sponsored by Avista.
Well, hello again, folks. I am Ken Sax, and once again, you are listening to Real Estate Talk. And I'm always excited, and I always say that, I know that, but I'm really excited today because we have an attorney in the house. And we are going to be talking about seller disclosures, sellers, and what are seller disclosures? What does it mean to you as a seller in completing seller disclosures? Do you need to complete seller disclosures? What if you don't? What if you change them, modify them? What has to be disclosed? All of those things that are ever so important to you, seller, and also to a buyer, to see what is or is not material with regards to the condition of the property. So that's what we're going to talk about today. And my guest is April Anderson. And April is with Randall Danskin here in Spokane, Washington. So April, welcome and thank you for being here.
Thank you for having me. I'm
You
happy
bet.
to be here.
Absolutely. Give us just a quick intro on yourself and what you're all about.
Sure. Yeah, I've been practicing in Spokane for my entire career,
Okay.
which is about 15 years now. And I handle a lot of real estate, both residential and commercial, and just general corporate business transactions.
Good.
Yeah.
And I was reminding April of I think it's a funny story, how we actually first came in contact with one another. And this was probably 6 or 7 years ago. Where I get a lot of demand letters. I'm the designated broker for Keller Williams Spokane, the largest firm in Spokane. And so just by nature of how much business we do, every so often I get a letter from a lawyer. And I remember back, like I said, 6, 7 years ago, I get a letter. It was from April. And it was probably the first letter, and probably still is one of the first letters that really got my attention. And so it impressed the heck out of me. And the attorney that I've used has retired. And so I am ecstatic now that I use April with a lot of stuff now moving forward. So that's kind of the funny story. And now look at us today.
Yeah, thank you very much. It is a compliment to have you work with me after that. It says a lot.
You
and
bet.
I appreciate it.
It was just, I love the way you work.
Thank you.
So seller disclosures, April.
Yes.
How does it pertain to me? I want to sell my house.
It pertains to you. So, and under our law, anyone who's going to enter into a transaction involving real estate, the sale of real estate, has to complete a form.
Okay.
Now we have different forms for different types of sales. So
Lots of forms.
regardless of the type of your property, whether it's commercial or residential, improved or unimproved, you're going to have to provide a form.
Okay.
Now, if you don't provide a form, there are some consequences to that, which we can get into.
Sure.
But it's, it is statutorily required. So I think, it's important to be aware of that, but also to understand that based on the type of your property, you may have to use a different kind of form.
Okay.
So not one form fits all.
Sure. Fair.
Yeah.
So I am going to sell my single-family residential property, and I'm listening to you telling me that I need this form. I need to complete this form, seller disclosures. What are the requirements around that form? So you give me the form. What are my obligations?
Yeah. So, the form, even though it's not technically part of the purchase and sale
Right.
agreement, and it can be filled out prior to actually having an agreement in place. I
Okay.
think a lot of people do that in practice. But what it does is it gives kind of a fill in the blank. So you can find a form with your broker if you're represented by a broker, which is always a great start.
Mm-hmm.
If you're not, there is a statute which I can give you the site to. It's RCW 6406005 is where it starts. And then there's forms throughout. So for unimproved, improved, and commercial, there's different forms set out in different statutes
Okay.
underneath that site. And so you can go there to pull the information that's required for you to fill in. So throughout the form, there's a lot of different blanks. It's very, very important you complete every single one of them. And I think you can attest to this in your experience that it's fairly common that doesn't happen. And this is, even though it's separate and apart from the purchase and sale agreement, it is a document that forms a basis for liability. So we want it to be complete and accurate in, so filling in the blanks and being as thorough as possible is step one.
Sure.
You can save yourself a lot of headache by just doing the basics there. And I want to back up for just a moment too. I said at the start that it's required that all sellers provide this form. What I failed to say there is that unless an exception applies.
Sure.
So there are several statutory exceptions, the most common of which is the buyer waiving the right to receive the form.
Okay.
And, there are instances where that is probably more appropriate than others, such as where a seller is, a trustee under a trust or an inheritance situation and doesn't have any knowledge about the property itself. So, that's something that has to be done in writing where the buyer signs off on waiving. And then even with the waiver, there's certain requirements that can't be waived, such as disclosures concerning environmental issues.
Right. And I always tell sellers, and you kind of alluded to it, I tell sellers, look, it has to be accurate, complete, and current. And so current, it has to be on the most current revised form that we have. And they get updated periodically, but it has to be current, on a current form. Accurate, you can't lie.
You definitely can't lie.
You can't lie. It has to be accurate. And complete, just as you said, don't skip any questions.
Right.
And probably about 7 years ago, the state added a NA column. So when sellers say, well, Ken, my house is on sewer, it's not on septic. Seller, that's why we have the NA column. And as I was telling you, and as I tell brokers when I'm teaching this, I say that to every seller, and I think every seller, without exception, they return it back to me, and lines are skipped.
Yeah.
And we just got done having this conversation. So as a broker, and I tell our brokers, look, we're liable to a degree where when you get that back, and as an attorney, agree or disagree, you want to make sure your seller has indeed completed every question. And if they haven't, send it back and say, remember what we talked about? You're missing answers on these. Could the broker then say, oh, well, I know the answer, I'll check the box?
No. So as you know, and I'm sure your brokers know, there's liability attendant to that as well.
Yes.
So the statute also applies to brokers. And I mean, you definitely
Thank
don't. We definitely don't want to have people filling out forms for somebody else. This is supposed to be the seller's knowledge.
Seller disclosures, not listing brokers disclosures.
Right. So to back up a second, if somebody does fail to complete the form in its entirety, the consequence of that, I think, is interesting to discuss, because let's say that the broker doesn't catch it, and it gets sent on to the prospective buyer, and the buyer hangs on to it, doesn't rescind within 3 business days of receipt, but subsequently decides for one reason or another they don't want the deal and they don't otherwise have a way out.
Right.
Why would they then not say they didn't receive the form because it's not complete?
Right. And so what April is talking about is the form itself has language in there that says, buyer, you have a 3 business day right to rescind starting once delivery is made. And remember, delivery, we need to have accurate, complete, and current seller disclosures. So in this case, in our scenario, they were not complete because seller skipped some lines, skipped some questions. The broker did not catch it. Buyer and seller go under contract. Buyer has never received completed seller disclosures. 40 days into a 45-day contract, buyer wakes up and says, I don't know what we were thinking. We don't want to buy this house, or we found something different, or whatever. And now we're looking for, I call low-lying fruit on how to get out of a contract. Mm-hmm. Well, the disclosures were never delivered and buyer never received them in the condition they're supposed to be in. completed. And since the disclosures have that 3 business day right to rescind clause, guess what? Buyer can walk, not be in default, and that's going to be a tough conversation for that listing agent to explain to the seller what happened. Is that pretty accurate?
That is, yeah, that's nailing it right there.
Yeah. So listing brokers, come on. We have to make sure that all the questions are answered. And sellers, come on. You got to answer all the questions. I say that all the time.
Yep.
And we still don't get them completed.
Yes.
So, gosh, what else? So we understand we have to complete it. Where are sellers getting in trouble? They've completed it,
Yeah.
but where are they getting in trouble?
Yeah, so you talked about, sellers maybe checking a box about NA or the do not know box. So I mentioned before that the seller disclosure statement's not part of the purchase and sale agreement.
Correct.
It's supposed to be for informational purposes only. The statute provides for the right of rescission if you don't like what's in there. But what happens if the information that's in there is inaccurate or misleading or fraudulent is that you open yourself up to a whole host of potential liability.
Sure.
So just because you fill this form out and end up closing and there's no rescission doesn't mean you're free from liability. So when you fill it out, you've got to pay attention. So, there are a lot of tricky phrases in this form.
Yes.
To put it mildly. Material defect being one, actual knowledge being another.
Okay.
And so I think, as your seller goes through the form, they need to keep in mind that, if they bought this property and at the time they bought the property, if they had things like a property inspection report or a phase 1 site, environmental inspection, that anything that they had physical possession of or knowledge of in writing is certainly going to be something they have actual knowledge of.
Sure.
Actual knowledge is not going to require someone to go do their own investigation into the condition as to the questions asked on the form. But if there's a physical piece of paper, you certainly want to go pull that out, take a look, and refresh your memory as to what it said, because you'll be deemed to know what it said. Because
Sure.
you at one time did know what it said.
Right. So do you think sellers ever kind of fall into the, well, if I say yes, the buyers may not buy my property and it's not a big deal?
Oh, all the time. So, I think there's a legitimate fear that disclosing something that maybe otherwise you could avoid disclosing based on the wording of, the interpretation of the
Sure.
wording, could lead to a lost sale or a, lost revenue from the price, maybe a purchase price reduction or something.
Right.
But in my opinion, the risk associated with failing to disclose something or inaccurately disclosing something far outweighs any, haggling over the purchase price that might ensue.
I agree.
So, when you're looking at post-closing lawsuits, because that's what's going to happen
Right.
if these issues come to light, you've got to hire an attorney to help you out through a process where you've received a demand from the buyer and the buyer's got a lawyer and they've likely tried to craft some arguments that would constitute breach of contract for recovery of attorney's fees and other creative ways to get attorney's fees. So you're paying your attorney hourly at a pretty high rate, usually $300 plus. And then, if you end up in litigation, that is tens of thousands of dollars plus damages to pay your buyer for something that may have been fraudulent or misrepresented.
All because I was afraid to disclose something that is probably most definitely not worth the cost of litigation.
Absolutely.
Yeah.
Yeah, the cost of litigation is so high when you're talking about something less than $10,000.
Mm-hmm.
I do some consults with people. Usually not. When we get into this realm, it's usually not even worth,
Right.
Going there. But I tell people if your claim's not at least $10,000, it's not worth it.
Sure.
The attorney's fees alone are going to exceed trying to collect.
Yeah, that makes a lot of sense. And you remind me something that I consistently tell my sellers too, and that is, a big part of my job and why I'm so strict on this is I want to save you from getting that call 7 months after the house has closed. You're in a different state. You're you've forgotten about everything, and the phone rings, and it's a lawyer.
Yep, absolutely.
Like, I want to protect my sellers from that.
We have a 3-year statute of limitations in Washington State for misrepresentation and fraud claims. So, you've got a few years for these folks to figure out something that's, not going well and to come back.
So, like, they buy in spring or summer, and then, the wet season rolls in, and what the heck? How did you not know about this? Or the neighbor, right? Because I always say it's the neighbor. Didn't you know about fill in the blank?
Right.
It's always coming from the neighbor. It is.
Neighbors are nosy sometimes.
Yes, that's exactly
They
right.
can be helpful, but other times it can be a detriment.
Absolutely. So I'm a seller, and I'm filling this out because we established the seller does it. The licensee broker does not do it. And you mentioned material defects. How do I even know? I'm thinking of something, and well, that's not really a big deal. How do I know if that's material? What is material defect? What's the definition of that?
That's a really good question, and it's not really well defined, frankly. But it is going to be a factual question, which is never good in terms of a lawsuit, because that means longer time to figure it out in the courts.
Sure.
But generally speaking, it's going to be something that is of a nature that if I knew about it as a buyer, it would impact my decision to buy, potentially, right? It would be something that is meaningful. So
what I'm hearing is that it's rather subjective. And depending on the quality of the attorney for the buyer, they could successfully argue that it's material.
Oh, absolutely.
Because it's not clearly defined, as you've said.
Yeah,
and
the
it's
cases.
subjective.
Yeah, the cases are not clear on what all would constitute a material defect. We do have, in the context of a seller disclosure statement, we do have a body of cases dealing with, other kinds of defects which we could pull from. But I think in this context, it's a little bit ambiguous, and there's a lot of room for interpretation. So, where that leaves us from, a risk analysis as a seller and somebody contemplating filling out a form and avoiding liability and risk is to err on the side of disclosure.
Absolutely.
Yeah. I've had cases where people will go so far as to put up drywall to cover up, evidence of past flooding. And of course, a buyer's inspector is never going to see the evidence of the past flooding. And then when they go to do work end up having flooding that happens through the drywall, then of course you're like, okay, you went to the lengths to actually cover this up.
Oh, but I didn't know it was there.
But how would it be material, right?
Right.
And it wasn't within the last, 5 years or whatever. You try to play within those questions, but at the same time, if you're going to the lengths to try to paint over something, to try to cover something, or if you're even asking yourself, I don't know if I should disclose this. If you're having to stop and think about it, you probably should.
Yeah, I like that. And you reminded me, it's actually the last question on the seller disclosures. And I love it. And the question, and these are seller disclosures, by the way, guys. And the last question on the page, it basically says, is there anything else a buyer should know before buying this house? And so I tell my sellers, if you complete the entire form and prior to reading that question, you think, whew, I am so glad they did not ask me about.
Right.
That probably applies to that question.
Yeah, definitely.
Yeah.
That's the catch-all.
That's the catch-all. So I love your advice. Sellers, disclose. I heard it in court once around 2005 when I was in court. Or I actually don't know. It was like 1995. And the expert witness said, disclose, disclose, disclose.
Yeah.
And I never forgot that.
Yeah.
So disclose, disclose, disclose. It's a house. And even with new construction, there are things that require disclosures. So I think, and we talked about it, what gets sellers in trouble is their reluctancy to disclose, because they think the buyer then won't buy the house, and the sellers don't want that to happen. So, it shouldn't be a big deal.
Yeah.
And like I said earlier, it's never a problem until it's a problem.
Absolutely. I mean, if there's a seller who's adamant that they don't want to make certain disclosures, one, that should be a red flag for the broker.
Yes.
I mean, because the broker is going to have some liability potentially for known issues
Absolutely.
if they're conveyed.
Yep.
And then also, I mean, in those instances, maybe try to get creative. Try to see if you can get a buyer waiver and negotiate something in exchange for that.
Sure.
You know, give a longer inspection period. Do a purchase price reduction, something.
Sure.
If the seller's really concerned about things and doesn't want to have the ongoing risk.
Good.
But like we said, there are the environmental aspects
Right.
cannot be waived.
Right.
So,
Good.
yeah.
Now, you mentioned before the show common law rights.
Yeah.
What's that?
So common law is basically just our cases.
Okay.
It's the decisions that come out of our courts, and they're not defined by statute. So the seller disclosure statement, that's a statutory requirement, statutory scheme, and it provides for a buyer's right of rescission if you fail to give the seller disclosure statement, or if you have to modify it because you learn of things that happen midstream. You know, you re-trigger that rescission right. But
Sure.
rescission rights are not the only rights available
Okay.
under that statute. You can revert to common law rights to establish things like fraud, misrepresentation against a seller who either doesn't complete the form or omits material information, misstates information, commits fraud, that kind of thing. So
I don't like the sound of any of that.
it's all pretty negative.
Yeah, it is all pretty negative. So we have about 30 seconds left. Again, my guest, April Anderson with Randall Danskin, and I cannot recommend April enough if you're ever looking for a real estate attorney. Is that legal to refer? I mean, I just did it.
Thank
so-
you. I
okay,
appreciate it. I
okay.
think it's legal.
Okay, good. If it's not, I didn't do it. Last words, parting words to our sellers out there?
You know, I think it was a good market. We're all kind of dealing with this pandemic.
Yes.
But ask the questions. Your brokers are there to help you. And
Yes.
they're constantly educating themselves. And Ken's on top of this.
Yep.
So disclose, ask questions, be diligent.
Awesome. April, thank you so much. Keller Williams Spokane for sponsoring this show. Cannot thank you enough either. And folks, we will absolutely see you next time, again on Real Estate Talk, and enjoy your day.
Thanks for watching. Ask the host a question, recommend a guest, or check out any of our other programs on Facebook, YouTube, Twitter, Apple Podcasts, Spotify, or SpokaneTalksMedia.com. Sponsored by Keller Williams Spokane.